This week, the court struck down Louisiana's congressional map, one the state was required to draw under the Voting Rights Act, after a court found the original map diluted Black voting power, designating 2 districts to accurately represent its minority population. Writing for the conservative majority, Justice Samuel Alito said the map was unconstitutional because it relied too heavily on race when drawing district lines. And what the court changes here is a standard. For decades, the Voting Rights Act allowed courts to step in when maps, congressional voting maps, intentionally diluted the political power of minority communities. Now, those communities have to prove intentional discrimination, as if those people drawing the lines don their KKK hoods as they're deciding what their gerrymandering is going to look like. Something commonly known to the extremely difficult to prove. As one election lawyer put it, you need a, quote, smoking gun to prove that intentional discrimination, which is why the Voting Rights Act gave the powers that it did. Which means that now, finding direct evidence, emails, statements, something explicit, that's what they're going to have to do. And in most cases, that will not exist. No one who draws congressional maps to benefit one race or another is going to be documenting it. The conservative majority's reasoning for this ruling is something of a distorted utopia. It views that these protections are no longer needed in the same way they once were, that the law has already done its job, that we are now living in some sort of post-racial society, even though the President of the United States regularly makes policy decisions about which races and ethnicities he's interested in seeing come into the United States of America. This logic is exactly what Louisiana's governor is grasping onto as he plunges the state's voting into chaos.